Welcome members and guests to today's webinar. We're delighted you could join us for our Women in Super webinar to celebrate tomorrow's International Women's Day. My name is Rebecca Harvey and I'm Manager, Key Member Services at Brighter Super. Here with me today is Loanne Chow, Director of YHC Lawyers. I'm honoured to present to you today on a topic that resonates with me in many ways, having experienced some challenges that can be presented to you during your working life. I've had 2 career breaks, having raised my children, and experienced a divorce, which impacted me financially. I've undertaken some of the strategies I'll present to you today, which is helping me to work towards a comfortable retirement. Before I start today's briefing, I'd like to acknowledge the traditional owners of the lands on which we are meeting and pay my respects to their elders past, present, and emerging. We acknowledge and celebrate the continuation of a living culture that has a unique role in this region. Today's presentation will run for 45 minutes and is designed to provide you with some top tips on preparing women for a comfortable retirement. Please feel free to submit any Brighter Super questions you have by pressing the purple speech bubble icon on your screen. We have Ali and Laura looking after the chat today and will endeavour to answer any questions you have. Should we run out of time, we'll get back to you in the coming days. For questions specifically for Loanne, you'll have the opportunity to submit a question at the end of the seminar and she'll get back to you directly. Before we start, I'd like to also advise you that the information we are presenting today is general information only. It has been prepared without taking into account your individual objectives, financial situation or needs. You must not rely on the information alone as a sole or primary source of advice or guidance for the purpose of making decisions about your superannuation options. Our goal here at Brighter Super is to actively prepare you for a comfortable retirement. But what exactly does a comfortable retirement look like? Super is your money, so you might want to take an interest in it. Think about the following statistics. To have a comfortable lifestyle in retirement, a couple at age 67 need an estimated balance of around $640,000. For the same retirement lifestyle, a single person needs about $545,000. But in the most recent year on record, the median balance of a retired Australian woman is just $180,718. The large gap between these suggested amounts and the actual savings means that women are more likely to rely on the government's age pension, which is only designed to cover the basic essentials. So, why do women need to plan for retirement? There are 2 main reasons women should start looking into planning for their retirement sooner rather than later. Firstly, women have a longer life expectancy. Did you know that women retire on average with 24% less in their super than men? Did you also know that women are expected to live longer than men by around 4 years? And on average, they retire younger than men. At a very basic level, this means women are retired for longer than men and with less super. Secondly, we have an ageing population. Between 2000 and 2020 years, Australia's ageing population, those aged 65 years and over, increased from 12.4% to 16.3%, while the working age population decreased. This means there will be fewer tax-paying Australians to help fund the government's age pension. It's important to understand why women retire with less super than men. Super is linked to income. This is why generally women retire with so much less super than men. According to the Workplace Gender Equality Agency, many women earn less than men. The wage gap currently shows that men in Australia earn on average 22.8% more for exactly the same job. Women are more often employed in lower paying, part-time or casual jobs, leaving even less opportunities to build super. As women, we spend more time out of the workforce, which ultimately impacts the opportunity to build superannuation, not only through the loss of income whilst on a career break, but also accumulating over time when re-entering the workforce. Women are also more likely to take career breaks to care for children or elderly parents than their male counterparts. Separation and divorce can play a significant role in reasons women retire with less super. No one goes into a partnership expecting it to fail. However, statistics show us that life very rarely goes to plan. According to ABS data, 1 in 3 marriages end in divorce. Did you know that of the women who divorced in Australia, 59% experienced financial hardship? Divorce can be so financially harmful for women that it has been identified as one of the main causes of rising homelessness among Australian women, with single older women the fastest growing group among the country's homeless. Protect yourself by understanding, managing, and most importantly, boosting your super. If you do get divorced or a de facto relationship breaks down, remember superannuation is an asset to be considered when negotiating a financial settlement. Some of your ex-partner's superannuation could be split into your account to help ensure you're set up for retirement. Rising divorce rates, widowhood, and greater female longevity mean that women need to plan independently for their retirement. Around 1 in 3 women have no super savings. This can be because they have never had super or taken it out. Superannuation can provide women with a range of benefits. These include a greater financial independence in retirement, such as the ability to live a comfortable lifestyle and make financial decisions for themselves. Secondly, a tax-friendly pool of retirement savings. Superannuation offers a range of tax-effective methods of saving for retirement. And thirdly, access to cost-effective insurances such as death and total and permanent disability or income protection through your super fund. Having cover via your super fund can be a convenient and tax-effective way of arranging financial protection in case of death or permanent or temporary disablement. For a range of reasons, from rising divorce rates and widowhood to greater female longevity, it means that women need to plan. The good news is that with some planning, you reap the benefits of super. Here are 6 simple ways you could take to boost your retirement nest egg. But remember that not all strategies will suit everyone. Examine your personal circumstances and, if required, seek professional advice. So, top tip number 1, consolidate your super. Around 26% of Aussie workers have more than one super account. Take a moment to think about how many super funds you're with. A question's going to pop up on your screen to answer. We will share the results with you shortly. While you're answering, here's something to think about. As women often take time out of the workforce and can often be in part-time or casual roles for a period of their working lives, having one single super account can help reduce your losses due to excess fees. Because when contributions aren't going in, admin fees and insurance premiums may still be coming out. Lost super is a big issue for many women who may change their name, address, or job, but there are ways to find it. When you find your super and add it all together, it's known as a rollover. You may know how many super funds you have, or you may have some lost super. To consolidate your accounts, log into MyGov and use the linked ATO service to consolidate your super online. It's as simple as that. The question was, how many super funds are you with? The results are really interesting, and you can now see where you sit compared to others in the webinar. Everyone is different, so you should consider what's best for you. Before consolidating, you should check whether this could result in changes to your employer contributions, any fee or tax implications, or loss of insurance cover. Our next top tip is salary sacrificing. This is when you make an additional contribution to your super from your before tax pay. This essentially reduces your taxable income, reduces your tax liability, and can provide a tax-effective way to boost your super. A salary sacrifice contribution is taxed at 15%, which for anyone earning more than $45,000 per year is a lower rate than the marginal tax rate. Not all workplaces offer salary sacrifice arrangements. You'll need to find out from your employer if this option is available to you. To illustrate the tax attractiveness of super, I'd like to take a moment to look at a case study. Let's assume this member is contributing $5,000 to their super and they earn between $45,000 and $120,000 per year. If they make an after-tax contribution, the tax paid would be $1,725. If their employer allows them to salary sacrifice, or if they claim a tax deduction, they would be saving around $975 per year based on the difference in tax rates. That's extra money in your pocket. Let's move on to our second poll question for today. How many are already making salary sacrifice to your super? It's up to you as to what you do with this money. You may have immediate financial commitments or looking towards the future. It can potentially be a great way to boost your retirement savings. Remember, it's all about lifestyle. Now that we know how many are salary sacrificing, let's look at an example. Recently, Jenny received a pay rise of 5%. In an attempt to boost her super, she chose to put 1% of her raise into super via salary sacrifice. Over time, with the effect of compound interest and investment returns, this could work towards building a comfortable retirement. Upon considering her budget, as this was money she did not expect to have, she determined that 4% of the raise would assist in her immediate expenses. However, she did not necessarily need the additional 1%. This is one example of how small contributions can help shape your future retirement. Here, we're assuming that Jenny is going to start making regular contributions by salary sacrifice. We've also made some assumptions in relation to her investment returns. Let's look at a 5-year period and topping up her super by an additional $5,000 contribution each year. If Jenny was to put the $5,000 as an after-tax contribution, her projected super balance would be around $278,000. After seeking some personal advice, she decides to make the extra contributions via salary sacrifice. As we can see, this relatively small change will help Jenny have about an extra $21,200 in super, with over $5,000 of this being money that otherwise would have gone in tax. A recent change allows you to potentially carry forward any unused concessional caps from previous years. It came into effect in the 2019-2020 financial year and ceases in the 2024-2025 financial year. To be eligible, you must have a super balance under $500,000 at the start of the appropriate financial year. Let's just look at the last 3 financial years and how this works. In 2020-21, the concessional cap, was $25,000. If a member contributes $10,000 concessionally, the unused cap of $15,000 transfers to the next financial year. If in 2021-22 they again contribute $10,000, the unused cap is now $32,500, which is carry forward to the next financial year's limit. You can view your previous concessional caps via the MyGov website and recommend seeking personal advice to see if this is the right strategy for you. This actually could help you if you've taken time out of the workforce, as it can be an opportunity to get on track for retirement. We understand that it may not be realistic to utilise the full carry forward unused cap. However, even small amounts over the long term are really beneficial. Under federal government rules, there are limits as to how much you can contribute to super each financial year to receive tax concessions. The concessional contribution limit for the current financial year is $27,500. Concessional contributions include employer, salary sacrifice, that can be mandated or voluntary, and tax-deductible contributions. If you exceed the cap, excess contributions are taxed at your marginal tax rate. Up next is to look at after-tax contribution options, also known as non-concessional contributions. There may be times in your life when you're able to make either ongoing or one-off substantial extra contributions to your super. Under current rules, you contribute up to $110,000 per financial year. If you are under 75 years of age at any time in a financial year, you may be able to bring forward the next 2 years' non-concessional contribution caps. This means you may be able to contribute up to $330,000. Eligibility criteria may apply, so please contact us for more information. Since the 1st of July 2022, there is no longer a need to meet the work test if you are making or receiving voluntary contributions, which includes after-tax contributions to super. If you are aged between 67 and 74 years, you will, however, be required to meet the work test in order to claim a personal superannuation tax deduction. To meet the work test, you must be gainfully employed for at least 40 hours during a consecutive 30-day period in the financial year in which the contributions are made. If you're over 55 and selling your primary residence, you can also put part of the proceeds into your super on top of the non-concessional bring forward amount. This is called the downsizer contribution. It's important to note that you must have lived in the home for at least 10 years, and this can only apply after the age of 55. There's no need to meet the work test regardless of your age and also regardless of the balance of your super. Other rules also apply, so please contact us for further information or refer to the ATO website. It's important to understand your investment strategy, which brings us to our next top tip. When you retire, generally 70% of your nest egg is made up of your investment returns. This means that the remaining 30% is a direct result of your contributions. You always have the choice of how you want your super invested. It's a good idea to review your investment option to make sure it suits your financial situation and goals. Our default option is My Super, but we have a wide range of options to cater for everyone's needs. You can switch to another option at any time. Although the investment options shown on this slide are specific to Brighter Super members, the investment principles we'll be covering apply to everyone. You need to consider the balance between risk and return and the time frame involved. A lower risk option, such as cash, will have limited volatility in the short term and also be more conservative in the longer time frame. High risk options can regularly change in value, however, they will generally provide a higher return over the longer time frame. A good general rule with investing is diversification. This simply means spreading your investment across a range of different asset classes. When considering an investment option, 3 of the most important factors to consider are your age now and when you plan to retire, this is called your investment time frame, your financial goals, the returns needed to achieve a comfortable retirement, and your tolerance for risk, so the level of investment risk that you are comfortable with at this stage in your life. Our recent performance has rated Brighter Super's My Super option as second in the National Super Ratings rankings. Super Ratings is a leading independent organisation that collects investment returns data for the largest super funds in the country, and they use this information to rank the various funds in order of investment returns. With an investment returns performance figure of 4.1%, this is 1% above the industry median performance. My Super is the default investment option for our members, with approximately $12 billion under management. Should you choose to move out of this default option, you can see that our growth and balanced options have also performed admirably in a relatively volatile environment. You can view all our investment options on our website and make a choice that is best for you and your circumstances. We recommend seeking personal advice with us. One of the best things to start doing is to get a better understanding of your super account and which investment strategy best suits your needs. Find out what account balance is today. Then look at what contributions have been going in, your investment returns and fees. Ask yourself, how healthy is My Super looking? The quickest and easiest way to view your account is by logging into Member Online or contacting us. Now, we're on to top tip number 5. There are a range of other super contribution options. One of those is the government super co-contribution. You could be eligible for this co-contribution if you make after-tax contributions to your super. It's particularly beneficial if you earn less than the lower income threshold, which is $42,016 for the 22-23 financial year. If you are eligible, the Australian government will make a contribution of up to $500 or 50 cents to the dollar. Eligibility is determined using the lower and higher income thresholds of $42,016 and $57,016 for the 22-23 financial year. If you earn less than the lower income threshold, you can receive the full $500 entitlement. If your income is between the lower and higher thresholds, the maximum entitlement you can receive reduces as your income increases. Once you reach the higher threshold, you are no longer eligible. Let's have a look at the next one, which is spouse contributions and tax offset. If you or your spouse make an after-tax contribution of at least $3,000 to your partner's super, you'll help them grow their savings and save a little extra on tax yourself. To receive the full tax offset of $540, your spouse must have an annual income of less than $37,000. The offset gradually reduces for income above this level and completely phases out at a total annual income of above $40,000. Rules do apply. This isn't a complete list, and you can view other super contribution options available. These can be viewed on our website under the Resources tab, or contact us for more information. Number 6 on our top tips is to nominate your beneficiary. Our last poll is, do you have a current beneficiary nomination? While answering, just remember when it comes to beneficiaries, you'll need to give your super fund instructions as to who your money goes to in the event of your passing. Super funds can generally only pay your benefit to a dependent, which is a spouse, child, or children, financial dependent, or someone in an interdependent relationship, or your estate. So it's interesting, and it highlights the importance of having a beneficiary. Let's dive a little deeper into the type of beneficiary nominations that we have. Preferred is a guide to how you would like your benefit distributed in the event of your death. For Brighter Super members, this can be completed online, and there's no time period. Brighter Super is not bound to pay your death benefit to the person or persons you have nominated, and is legally required to identify all your dependents and pay your benefit according to the rules set out in our trust deed. The second type is a binding death nomination, which legally binds Brighter Super to pay your death benefit to your nominated beneficiary or beneficiaries. This must be completed in writing and witnessed by 2 people, and beneficiaries must be a dependent or legal personal representative or your estate. A binding nomination is valid for a maximum of 3 years, and we will notify you prior to its expiry. You also have got the option of a non-lapsing binding beneficiary, which is the same as above but has no expiry date. Both binding options have different legal criteria. It is important to review the information to ensure this will be binding and valid on the event of your passing. Our last one is reversionary. Reversionary is only available in a pension account. A reversionary beneficiary will allow the income stream to continue to be paid and directed to your beneficiary, which is generally your spouse. To continue the conversation on effective estate planning, I would now like to hand over to Loanne Chow, Director of YHC Lawyers.
Thank you, Rebecca. My name is Loanne Chow, and I'm a Director of YHC Lawyers, a wills and estates law firm in the Brisbane CBD. I have practiced exclusively in wills and estates since 2005. There are 3 areas in wills and estates, and the first one is estate planning, which will be what we're talking about today. That's the preparation of wills, enduring powers of attorney, and advance health directives. Sitting down with couples or singles, talking about who you'd want to manage your affairs if you lost capacity or passed away. Estate administration is when someone has passed away and the family brings me all the paperwork to deal with collecting in the assets, applying for probate, distributing the estate in accordance with the testator's wishes. This is often where I become the family referee, because mum and dad, who were the glue that kept everyone together, are no longer with us. And suddenly all those years of sibling rivalries or family dynamics come to pass. Estate litigation is when people fight, usually over money. When we handle our estate planning, we make sure that we look at the practicalities of estate administration and estate litigation and make sure that all the steps have been taken to ensure an effective estate plan. When we talk about an effective estate plan, we're really talking about making sure that the wills, enduring powers of attorney, and advance health directives are in place. But first, I want to let you know that the information I'm giving you today is just general information. It's not advice. As a Queensland-based practitioner, most of what I talk about will be based on Queensland law. So in your situation, you'll need to seek your own independent legal advice based on your personal situation. First of all, we're going to talk about wills. So why do we make a will at all? Well, it's really about control, isn't it? It's about choosing the right person who's going to be your executor. The executor is the person that you trust to arrange your funeral, meet with your lawyers and accountants to collect in your assets, pay your debts and taxes, and distribute your estate in accordance with your wishes. If you die without a will, then someone has to apply to the Supreme Court to be appointed as the administrator of your estate. The law sets out an order of priority which needs to be followed. And in Queensland, that order will be your spouse, then your children, then your grandchildren and great-grandchildren. then your parents, your brothers and sisters, the children of your deceased brothers and sisters, your grandparents, your aunts and uncles, your first cousins, and anyone else that the court may appoint. So the person who applies to become your administrator may not be the person that you would have chosen. To ensure that doesn't happen, you need to have a will and appoint your own executor. The other reason to make a will is to make sure that you control who will receive an inheritance from your estate. If you die without a will, your estate will be distributed in accordance with a legal formula which is black and white, and it doesn't give any reference or consideration to your wishes or the quality of your family relationships. So for example, in Queensland, if you have a spouse and you have children, and then you pass away without a will, your estate will not automatically go to your spouse. A large part of your assets will pass to your children. This is not the outcome that most people would want to have for their spouse. Most couples would want to give everything to each other to make sure that their surviving spouse has the financial security and flexibility to provide for their family. So to make that happen, you need to have a will. And when you don't have a will, your wishes don't apply. So what should you be taking into account when you're putting together your estate plan? Well, estate planning is really about doing a financial health check. It's about sitting down with your lawyer and making a list of all your assets and liabilities and making sure that you're on top of all those details. Your lawyer should check your life insurance nominations and your superannuation beneficiary nominations to make sure they're correct and up to date. Superannuation doesn't form part of your estate and is not dealt with under your will. You can make a nomination of who you would like to be your beneficiary. And as Rebecca said, it would be your spouse, your children, your dependents, your interdependents, or your estate. If you're single, then the only option you have is your estate. So you absolutely need to have a will to make sure that your assets pass to the right people. Your lawyer should also run current title searches on your properties to make sure that the way you believe you own your property is the way that the titles office has it recorded. There are two main ways that you can own property with other people. The first one is called joint tenants, and this is the one that married couples typically have. If you own a property as joint tenants, it means that if one person passes away, the other person receives it. It happens automatically and it happens outside of your will. There's still a process and there's still paperwork, but that legal ownership is secure. The other way you could own property with another person is to own it as tenants in common. Tenants in common means you each have a share which you can give away under your will. There are legal and tax consequences to take into account, so you need to make sure that the current title searches are run and that you speak with your lawyer about making sure that the property passes in the way that you would want it to pass. If you have a family trust, a family company, or a self-managed super fund, you'll need advice from not only your lawyer but also your accountant to make sure you understand what would happen to the control of that company or that trust, or the assets in that company or that trust if you were to lose capacity or pass away. There might be additional clauses that need to be added into your will and your enduring power of attorney to ensure the smooth transition of control. But one of the main reasons why people have not organised their wills is simply because they cannot agree or they cannot decide who should be their executor or who should be their guardian. These are two completely different roles. The executors are in charge of the paperwork and the money. The guardians are in charge of the welfare of your children, if you have children under the age of 18 when you've passed away. When you choose your executor, you don't need to choose anyone who's legally trained or financially trained because lawyers will do their jobs and accountants will do theirs. But what you need is someone who is completely trustworthy, 100% proactive, good with paperwork. If you send them a form, they'll sign it and they'll complete it and they'll send it back to you. If you leave them a voicemail message, they'll return your call. That is the sort of person that you need to have as an executor. It doesn't need to be a do-it-yourself person. In fact, it really should be someone who respects professional advice, will seek advice from your lawyers, your accountants, your financial advisors, and will follow that advice. In terms of guardianship, it's a completely different job description. The guardians will make long-term decisions about the welfare of your children, and that would be where they live, where they go to school, whether smacking's okay, it's not okay, what access they have to your friends and family. So when you're choosing a guardian for your children, what you really need to think about is choosing someone who has a similar parenting style to yourself and making sure that they will respect the family networks and relationships that your children have and maintain and nurture those relationships. Your children should also feel safe and comfortable with those guardians. Now, when choosing a guardian or an executor, you really need to think of the worst possible scenarios and ensure that you've nominated a couple of people. So you might say this person first, and if they can't do it, then this person, and if they can't do it, then this person. Always have a multi-tiered plan to make sure that there's always someone that can step up to the job if the people that you originally chose to do the job refuse the position because of their own situation at the time. Now, if you have adult children, there's something else that you should think about, and that's about making sure that you're protecting their inheritances from the ups and downs of life. So if your beneficiaries are in risk professions, and that means that they are lawyers or accountants, engineers, or they run their own business, then they're at the risk of being sued in their job. People like that tend to not want to have assets in their personal name, so we need to think about how we can best protect them. Another situation you might have is that you have a child that struggles with drugs or alcohol or gambling or spending. It could be that one of your children's marriages potentially could be at risk of being broken up. So in situations like that, you need to seek advice from your lawyer about how to make your will in a way that could add an additional layer of protection for your children. One of the problems that my clients get into sometimes is they've become the bank of mum and dad, and they have loaned or gifted a large sum of money to one of their children and not to the others. So if you've done that and you think the other children don't know about it or they're fine with it, I think you really should consider getting some advice around that. Clients often lend money thinking that it's a loan, and the people receiving the money think it's a gift. It never seems to be the other way around. Making sure that all of this is properly documented and you have the right advice is critically important. But one of the most important things we talk about is who can contest your will. So there are three main ways that your will could be contested. The first is to say that you lack capacity. In other words, you have no understanding of what a will is. You can't describe your assets and liabilities. You don't comprehend who could bring a claim, or you're suffering from some kind of mental or medical condition that impacts your decision making. The second way that your will could be contested is someone says that you've been unduly influenced by another person. In other words, someone else has forced you down a path where you've made a will that isn't your own free and voluntary choice. But the third way that your will could be contested, the most common way, is a family provision claim. A family provision claim means you've left me out of your will and you shouldn't have, or you left me something under your will and I don't think it was enough. Now, the rules around who can contest that will in that way and the timeframes in which they need to contest it differs from state to state. But in Queensland, it would be your spouse, your children, and your dependents. So the spouse is the person you're married to, but it's also the person that you've been living with on a genuine domestic basis for a period of 2 years. And a de facto partner has the same rights to contest your will as though you're legally married. What's really interesting, though, is that your de facto partner's children have now become your stepchildren. And stepchildren have the same right to contest your will as your own biological children. Even if you hardly know them, you've never met them, even if they're older than you. So you absolutely do need proper legal advice about what are the potential risks of your estate being litigated. Your adult children can contest your will no matter what age they are, and even if you divide the estate equally between them. So some people say, well, if we've divided the estate equally between them, why would they contest it? The reason is we just don't know what their financial circumstances will be at the time that you pass away. It could be that two of your children are living their best lives, having fantastic careers and marriages, everything's gone well for them. And the other child, unfortunately, has had a marriage breakup, or they've lost their job, or suffered an injury at work, or they've got a special needs child. That child looks at the other two siblings and says, you know what, it's really not fair that we get an equal share in the estate. You basically print money, I struggle to make ends meet. That child, the disappointed beneficiary, has a right to contest the will. And in Queensland, what they have to prove is a moral claim and a financial need. And then the other children who were not going to rock the boat, who were not going to contest the will, also have to give the court details of their financial circumstances and their health situation, and the financial circumstances and health situation of their partner and their children. And then the court will weigh out what's fair. So this is something that a lot of people don't know about. And when you tell them about it, they get pretty upset. So it's really important that that's a part of your estate planning. In a world where you can buy a will kit or do an online will, why would you go and see a lawyer? Well, the reason is because of this, because of potential estate litigation. Lawyers can advise you on who has the right to bring a claim and what they have to prove to bring a successful claim. They can also obtain medical evidence at the time of your making of will that you understand the nature and effect of a will, you understand your assets, you understand who can bring a claim, and you're exercising your wishes free of any undue influence and free of any medical conditions or medications that impact your decision making. We can also provide evidence that you understood the instructions that you gave and that you were not under any undue influence at either the time of making the instructions or signing your documents. What we like to do is we like to set out in a statutory declaration all your reasons for why you did your will in the way that you did. It's not about chapter and verse about every terrible thing that happened, but it is about making sure that the judge understands your side of the story. Because so often when wills are contested, the disappointed beneficiary says terrible things about the will maker, but the will maker's passed away and they don't have a right to reply. We take a very proactive approach and we set out your story about why you did what you did, why you favoured some more than others, or why you left someone completely out of the will. And as I always say to my clients, if the will's never challenged, then this never sees the light of day. But if the will is challenged in the future, then we have the medical evidence to support your documents. We have the contemporaneous evidence from your solicitor proving that you gave your instructions alone. And we have all the evidence in your own words about why you did what you did. And that will give your executor the best possible chance to defend your estate. So we spent a lot of time talking about wills and why they're so important, but now I want to talk about enduring powers of attorney, because this is even more important in many ways. It impacts your quality of life. Wills are for your assets after you're gone. Enduring powers of attorney are for while you're still alive, but you can't take care of yourself because of illness or injury. So if you're married or if you're in a relationship, your spouse does not automatically have the right to make financial and health decisions for you if you lose capacity. You need to make an enduring power of attorney, and you really need to have backup options in case you're in the same accident. So when we talk about the enduring power of attorney, there are a couple of roles. The first one is the principal. You are the principal, and the people that you're appointing to make decisions on your behalf are called your attorneys, and they can make financial and health decisions on your behalf. So financial decisions means they can operate your bank accounts, they can sell off your shares, they can shut down your super, they can fire your accountant, they can sell your house and put you in an aged care home. Health decisions are where you live, what you eat, what medication you're taking, who's switching off your life support, who's taking you to the doctor, what access you have to your friends and family. So again, these are roles where you need to make sure that you trust the people who are making those decisions for you 100%. If they get it wrong, then there's nothing left in the estate. You can choose when the power to make financial decisions begin. You can choose for it to begin immediately, which is not something I recommend. You can choose for it to begin after a certain date, but that's hard to predict. What I recommend is that it only begins when the doctor certifies that you're incapable of managing your own affairs due to physical or mental incapacity. So it's not just a bad day in your relationship. A doctor actually has to certify that you no longer have the ability to manage your own affairs. I think that's a really good safeguard, and I think it's important. When you choose your attorneys, you need to make sure that you set out the order in which they make their decisions. So the easiest thing would be, and the most convenient way, is to appoint one person. Then if they can't do it, another person, and if they can't do it, another person. But sometimes people are tempted to appoint attorneys jointly. Jointly means they must consult each other, make all decisions together, and where signatures are required, both must sign. So while it's a little bit less convenient, it is a more protective method of decision making. It's something that you need to discuss with your lawyers, not just the practical dynamics, but also how it's going to work with the people that you have in mind. In Queensland, if you don't have an enduring power of attorney, then someone will have to apply to the Queensland Civil Administrative Tribunal, called QCAT, to decide who should be appointed as the administrator for financial decisions and your guardian for personal health decisions. If there is a dispute among family members, then the public trustee or the adult guardian might become involved. What I'd like you to do is I'd like you to check your enduring power of attorney. First of all, make sure that it covers financial and health decisions. Then I want you to make sure that there are clauses in there to deal with superannuation, terminal illness, maintenance for each other and the children if you have dependent children, temporary guardianship in case if you're both in an accident, someone can go to the school, collect the kids and look after them until you're out of hospital. Make sure there's a clause in there that recommends that your attorney seek financial, tax and legal advice. There should also be a clause in there to deal with assisted living. So some of you might be thinking, I already have a will and enduring power of attorney. Why should I update it? Well, every 3 to 5 years, you should pull out a copy of your will and enduring power of attorney and just ask yourself a couple of questions. Have your financial circumstances changed? Have you gifted specific gifts to your beneficiaries which no longer exist because you've sold them or they've lost their value? Have your personal circumstances changed? Have you got into a new relationship? Have you gotten married? Have you divorced or separated? Getting married or getting divorced cancels parts of your will, so it's really important you seek legal advice in that respect. Some people think that when you get divorced, that's when you make a new will, but actually it's upon separation. And the reason for that is the last thing you want is someone who you're not getting along with in control of your affairs. And separation is a long road between separation and divorce. You want to make sure that you've appointed someone who you know will act in your best interests. It's actually really empowering to get on top of your financial affairs, understand your finances, and make your own decisions about your future. And the beauty of it is that you don't need anyone else's cooperation. You can make these decisions for yourself. If you have a blended family, you absolutely need special legal advice about how your estate should be distributed if one or both of you pass away. It's a difficult conversation, and it can be very confronting. Sometimes I'm sitting in front of people who are saying for the first time out loud how they truly feel about their partner's children and what they worry about if their partner loses capacity or passes away. But it's really important that you get that information at the same time and you make some decisions and you put a plan around what is to happen. It's also critical that you make sure that your current documents reflect your current state of affairs. The only other thing I wanted to talk about was advance health directives, which are medical legal documents where you set out what end-of-life decisions you want to be made on your behalf if you are terminally ill or you've suffered a catastrophic injury or you've been kept alive on life support. Without an advance health directive, your attorney under your enduring power of attorney will make those decisions. It's important that you see your doctor and your lawyer to write down all your medical conditions, medications that you're taking, any religious beliefs you have that impact your decision making. You can name and shame the family troublemakers and make sure they're banned from the hospital. But what it's really about is making sure that you've made the decisions in the advance and then people can follow them. Because it's one thing to hypothetically know that someone doesn't want to be left alive on the machine, but to be the one to tell the doctor to withdraw treatment can be very difficult. So putting together your effective estate planning, your will, your enduring power of attorney, and advance health directive is really ensuring that there is a smooth transition for your family members and your loved ones. Some people get quite angry and depressed when I say to them that people can contest their will and they think, well, why bother? Or it's all too hard. But really, I don't think you should get depressed or complacent. I think you should get informed and organised, and knowledge is power. So one thing you can do for yourself is to make sure that your loved ones are looked after and your quality of life is ensured. Once you've made the first appointment, it's much easier after that. You go through the process and you're going to feel so much better knowing that there's a plan in place, which will give you and your family some peace of mind. Thank you for your time.
Thanks, Loanne. You've raised some really valid points today, and I'm sure everyone's gotten a lot out of that, and you can now feel a little bit more empowered about your next steps. I do understand that some of you may have had issues with our chat feature today. We will be able to submit, or you will be able to submit questions at the end of today via our QR code. So our apologies for that. So next, where do we go from here? So if you'd like to find out more about growing your super, including what investment option might be right for you, our team of superannuation specialists and financial advisors are here to help you. So our bonus tip today is to get advice. At the Brighter Super Group, we're here to provide you with both limited and personal advice about your super. Limited advice is available at no additional cost and covers a range of topics as seen on your screen. Alternatively, you can book in for a meeting with one of our comprehensive advice team for a more detailed financial planning advice. This can cover areas outside of super, and the advisors will discuss any costs involved in getting the advice prepared. So before we finish today's presentation, we want to remind you of our top 7 tips to prepare you for retirement. Consolidate your super, have a look at salary sacrifice. Also, can you make any after-tax contributions? Understanding your investment strategy. What other super contribution options may be available to you? Making sure you've nominated a beneficiary and it's up to date. And our 7th tip, get advice. If you wish to speak with either Brighter Super or YHC lawyers, please scan the QR codes on your screen now. When scanning the QR code for Brighter Super, you'll be given a range of options, including insurance, contributions, or investment advice, or a super health check. Super health checks can be done over the phone or via video call at no additional cost. We look at your superannuation account, discuss different ways to grow it, and check that you are on track for a comfortable retirement. Loanne and I have enjoyed spending time with you today, and I sincerely encourage you to own your financial future, to have the outcome you deserve in retirement. I covered many different super top tips, but there could be more available to you. Please contact us. We want to help you on this journey. If you have any spare money, even a small contribution into your super today can make a big difference to your future retirement. Your money can keep growing over the long term thanks to the power of compound interest. That draws our webinar today to a close. Thank you once again for attending, and happy International Women's Day.